Singapore's opposition chief and former transport minister have been separately charged with crimes. What's next? Today, you'll get a bird's eye view of the criminal justice process in Singapore. What exactly happens in a criminal case? Why could the process take years? If the accused is found not guilty, who pays for their lawyers' fees? First, a disclaimer. This video has been fact-checked by multiple lawyers and multiple articles written by lawyers. But this is not a substitute for legal advice. And the first question is, how does someone get charged with a crime? In Singapore, the police normally investigate crimes. For example, the police investigated Pritam Singh for allegedly lying to the Committee of Privileges. However, certain crimes are investigated by other agencies. For example, Iswaran's corruption case was investigated by the CPIB because they generally handle such cases. The Central Narcotics Bureau investigates drug cases, and so on. If the investigating agency wants to proceed, they will refer the case to the Attorney General's Chambers, or AGC for short. The AGC will then decide whether to prosecute. The Attorney General has the discretion to start, continue, and stop the prosecution. For example, if the Attorney General starts a prosecution, then nobody, not even the victim, can stop the prosecution. Even if the victim forgives the accused, the prosecutor can continue with the prosecution in the public interest. For example, in a domestic violence case, the prosecutor may decide that it's in the public interest to send a strong signal against domestic violence. Why should there be discretion to charge people with crimes? If there's no discretion, then the courts will be filled with jaywalkers and litterbugs. But deciding whether to prosecute can be difficult. When a government figure is not charged with a crime, or when an opposition figure is charged with a crime, there will always be those who howl political impropriety, regardless of how carefully and independently the decision was made. In Singapore, the Attorney General is appointed by the President on the advice of the Prime Minister. The President can reject the Prime Minister's advice, which is a safeguard against a political partisan taking the post. That said, former Attorney General Walter Woon has argued that it's better that the President directly appoint the AG instead. If the AGC decides to prosecute, the accused will have to show up in Criminal Mentions Court. That's where Iswaran appeared on January 18 and Singh appeared on March 19. At this stage, the accused can either plead guilty or claim trial. If they plead guilty, the court may hand out a lighter sentence, especially if the guilty plea is seen as a genuine sign of remorse. Iswaran and Singh have both pleaded not guilty. So the next step is a pre-trial conference, or PTC for short. PTCs typically handle administrative issues. Some examples. What issues need to be answered? For example, Singh is charged with lying. If he says that he didn't say anything false, then the upcoming trial will need to examine whether Singh's statements were in fact false. When should important documents be submitted? Administrative matters, such as the number of witnesses the accused intends to call. If the accused intends to call many witnesses, a longer trial may be needed. If the case is complex, there may be multiple pre-trial conferences. Iswaran's case may have a CCDC. It's not a musical tone, it's a criminal case disclosure conference. A CCDC has multiple meetings. Both the prosecution and the defense share the evidence they are going to use at trial. The summary of facts, the list of witnesses, the documents which will be used as evidence, and so on. This helps both sides prepare for the case. The conference only happens for certain criminal trials, like corruption cases. Singh's case will not have this. Even when a CCDC is allowed, either the prosecution or the defense may be able to opt out of it. In such cases, the CCDC will only occur if neither party opts out. Now comes the spicy part, the trial. At trial, the prosecution begins by outlining its case. Singh is charged with violating Section 31Q of the Parliament, Privileges, Immunities and Powers Act. No person shall willfully make a false answer to any question material to the subject of inquiry put during examination before Parliament or a committee. Singh is facing 2 charges of lying. For each charge, the prosecution must show 2 things. Singh gave a false answer, and he did so willfully. Iswaran faces dozens of charges, and for different offences: corruption, obtaining gratification as a public servant, and obstruction of justice. If the prosecution wants to succeed on all charges, it will have to prove that each different offence occurred. The prosecution will call on its own witnesses. Each witness may give a sworn statement, or the prosecutor may ask them open-ended questions. For example, the prosecutor can ask a witness, "What do you think of Singh's statement?" The prosecutor can't ask, "Do you agree that Singh lied?" because the question itself suggests the answer. This process is called examination in chief. Next, the defense team will get to ask those witnesses questions. It's a process called cross-examination. For example, the defense lawyers could ask prosecution witnesses, "How reliable is your memory?" Finally, the prosecution gets to ask its own witnesses questions in a process called re-examination. Obviously, re-examination tends to be a lot more friendly than cross-examination. If the prosecution fails to show that any element of the crime was committed, the defense can say, "There's no case to answer." If the judge agrees, either Iswaran or Singh will walk out as a free man, depending on which case we are talking about. Otherwise, the defense team will need to present its defense. The accused can testify as a witness or choose not to testify. Whatever the accused chooses, each defense witness will have to undergo the same process as each prosecution witness. First, they explain the evidence, then undergo cross-examination by the opposing lawyers, and then re-examination by their own lawyers. Cross-examinations tend to attract a lot of media attention. There's tension. Juicy revelations spill out. I wasn't able to find a video of a cross-examination in Singapore, but here's a video of a drug case in the US.
So you knew that when the police entered into the house that night that you were committing a felony?
Yes.
You knew that you were committing multiple felonies if you count the number of pills you possessed. Isn't that true?
Objection, Judge. That calls for a legal conclusion.
I would try it.
That's true.
I would try. It's fine.
At its core, it's a highly adversarial process, even if specific details differ across countries. If you want to see some cross-examination techniques, check out my video, How to Ask Tough Questions. After the defense finishes its case, the prosecution may make rebuttals. Finally, both sides make their closing submissions. These are the last attempts by each team to sway the judge to their side. Finally, the judge announces their verdict. If either Iswaran or Singh are found guilty, the sentencing will be announced at a later date. At the sentencing stage, the prosecution explains what sentence it's seeking and why. In Singh's case, the prosecution is currently seeking a fine, and the maximum fine for each offence is not enough to disqualify him from Parliament. In Iswaran's case, the prosecution could seek years of jail and fines of hundreds of thousands of dollars. The defense replies to the prosecution, and the prosecution replies to the reply. Finally, the judge announces the sentence. The judge may announce the sentence immediately, or may take a few days or weeks to decide. Both cases will take months and could take years. For example, City Harvest Church leader Kong Hee was charged in June 2012, but only received his sentence in November 2015, a gap of 3.5 years. And that wasn't the end of it. Kong Hee appealed and received a reduced sentence in April 2017, meaning the court process took nearly 5 years. Why do complex cases take years? There are many reasons. For example, both sides need to exchange documents. The process has many steps, and each step has multiple meetings. And the trial has to be fixed on dates which both sides can make it. The defense lawyer may have other cases already fixed for certain dates. Ditto for the prosecutor. The court also has to be available. Once the case is before a judge and the trial has started, it stays with that judge. Also, a trial may start for weeks or months before restarting. Sometimes one side might dispute some evidence, so there may be a trial within a trial to decide whether the evidence is valid. The bad news for Iswaran and Singh is that they are responsible for their lawyers' fees, even if they are found not guilty, unless they can show there was really no good reason to prosecute the case. The lawyers' fees are likely to run into the tens of thousands of dollars or even hundreds of thousands of dollars, at least for Iswaran. However, even if they are found guilty, they are not responsible for the cost of the trial, unless they conduct their defense in an extravagant manner, or do things that are clearly unnecessary. Thanks for watching this video.